Imagine waking up one morning and discovering that the Supreme Court has issued not one, but two seismic rulings, decisions so historically unprecedented, they immediately shake the foundations of American politics. Overnight, the legal landscape shifts, and with it, the country's political future, its immigration debate, and possibly the next several generations. And just as the media begins scrambling to make sense of the chaos, Marjorie Taylor Greene drops a bombshell, a leaked phone call involving the Epstein files and former President Donald Trump. Headlines explode. Commentators flood the airwaves. Millions of Americans are left confused, wondering what's true, what's spin, and what these developments mean for the nation they love. So today, we're going to break everything down calmly, clearly, and honestly. By the end, you'll understand why historians may one day look back at this week as a major turning point in American history, and why so many in the media seem desperate to control the narrative before the public hears the real story. Let's begin with the Supreme Court decision that sent an immediate shockwave through Washington, the ruling on the Texas redistricting case. On the surface, it sounds like a procedural legal dispute, but beneath the surface, this decision has the potential to fundamentally reshape political power in Congress for the next decade or longer. Here's what led us here. Like all states, Texas draws congressional maps after the census. These maps decide which communities vote together, and ultimately who gets elected to Congress. A few years ago, Texas redrew its maps in a way critics said would significantly benefit Republicans. Analysts argued the new lines could flip around 5 districts from Democratic to Republican control. A lower federal court stepped in and struck down these maps, arguing they amounted to racial gerrymandering, that is, drawing the lines in a way that divides voters based on race, which is unconstitutional. The court said Texas's intent was discriminatory, and therefore the maps couldn't be used. Texas disagreed and appealed to the Supreme Court, and that's where things took a dramatic turn. The Supreme Court's conservative majority overturned the lower court's ruling. They said the district court failed to give sufficient deference to the Texas legislature's stated intentions. In plain language, the Supreme Court said lawmakers should be presumed to act in good faith unless there is clear, overwhelming evidence of discriminatory intent. The court emphasized an important distinction. A map may have racial implications in its outcome, but that does not automatically mean the map was drawn with racial motives. Intent matters, and it matters more than statistical results. This ruling has enormous implications. It essentially sends a message to every Republican-controlled state in the country. If your map favors your party politically, and you can argue your intent was partisan, not racial, the Supreme Court is far more likely to allow it. Why is that important? Because partisan gerrymandering is legal and always has been. Every state does it. The tricky part has been the gray area where racial demographics overlap with political preference. For years, Republicans faced more legal challenges because reducing Democratic influence often meant affecting communities of color. This ruling changes that dynamic. The court is clearly moving toward an approach that prioritizes lawmakers' stated intent rather than statistical outcomes. Practically speaking, this could give Republican legislators far more freedom to draw maps that maximize their political advantage. Some analysts estimate such freedom could shift control of 20 to 40 House seats over upcoming election cycles, enough to determine the balance of power in Congress. That is not a small number. That is the difference between a fragile majority and a virtually unbreakable governing majority. But here's where things get even more consequential. This ruling hints at how the court might decide future cases involving the Voting Rights Act, particularly provisions that allow lawsuits based on discriminatory outcomes even when intent is unclear. If the court extends the intent over outcome standard nationwide, it could fundamentally reshape how elections are structured. Still, it's important to understand, the court isn't creating new law. It's redefining how existing law is interpreted. It's bringing more predictability to a process that has always been political, often secretly, often strategically, and often with very little transparency. However, if you thought that decision was historic, the second Supreme Court announcement may be even more transformative. On the same day, the court agreed to take up a case about birthright citizenship, a case that goes to the very heart of American identity itself. The debate centers on the 14th Amendment, passed after the Civil War. It declares that anyone born in the United States is automatically a citizen. Its original purpose was crystal clear: to guarantee citizenship to formerly enslaved people and overturn the infamous Dred Scott ruling. For over 150 years, the traditional interpretation has been simple. If you're born on American soil, you are an American citizen, regardless of your parents' legal status. President Trump challenged that long-standing interpretation with an executive order. His order stated that children born to parents who are in the U.S. illegally or under temporary visas should not automatically receive citizenship. Critics immediately called the order unconstitutional. Legal scholars on the left said the plain language of the 14th Amendment is unambiguous. They pointed to an 1898 Supreme Court case, Wong Kim, ARC, as definitive proof that birthright citizenship applies broadly. So why didn't the Supreme Court simply reject Trump's case? Why didn't they declare it obviously unconstitutional and move on? Because at least 4 justices believe there is a serious legal question worth examining. That alone is historic. Trump's legal team argues that the key phrase in the amendment, subject to the jurisdiction thereof, means more than just physical presence. They say it implies a deeper legal allegiance or permanent connection to the United States. Children of foreign diplomats are excluded for this reason. Diplomats aren't fully subject to U.S. jurisdiction. The administration argues that Wong Kim ARC does not support universal birthright citizenship. Instead, they claim it only applies to children of parents with established domicile, a permanent home, and long-term ties to the United States. Someone who crossed the border illegally last month, they argue, does not meet that threshold. Legal experts are divided. Some say the argument is weak. Others admit it's stronger than they initially believed. And many agree that the Supreme Court's willingness to hear the case at all suggests the possibility of a major reinterpretation of the 14th Amendment, a reinterpretation that could reshape immigration policy for decades. And all of this comes as political tensions are already at a boiling point. Into this environment steps Marjorie Taylor Greene with a leaked phone call involving the Epstein files and Donald Trump. Whether the claims are accurate, exaggerated, or entirely misrepresented, the timing alone sends the media into a frenzy. Suddenly, the week transforms from politically significant to politically explosive. Every network, every pundit, every politician feels compelled to spin the story before the public has time to understand what's actually unfolding. That's why it's essential to step back, take a breath, and look at the bigger picture. The Supreme Court's redistricting ruling could reshape congressional power. Its birthright citizenship case could reshape the meaning of citizenship itself. And the political storm surrounding the Epstein file leak ensures the narrative will be fiercely fought over, amplified, and weaponized. Historians may very well look back at this week not as a collection of isolated events, but as a turning point, a moment when legal, political, and cultural forces collided in ways that will shape the American future for generations. And as always, the most important question isn't what the headlines say, it's what lies beneath them. The debate surrounding birthright citizenship has simmered beneath the surface of American politics for years. But something fundamentally different is happening now. When mainstream commentators, people who usually dismiss anything connected to the immigration debate as fringe, begin saying they might not win, but they have a real case, it signals a dramatic shift in tone. It means this question is no longer theoretical. It's entering the realm of serious constitutional debate, and the Supreme Court is preparing to wrestle with it in a way that could reshape U.S. law for generations. Why is this happening in 2025, and why now? Part of the answer lies in the sheer scale of illegal immigration. Over the past several years, estimates range dramatically, but many analysts believe that somewhere between 15 and 30 million people entered the country unlawfully during the previous administration. That influx, unprecedented in modern American history, created a demographic and legal question the nation could no longer ignore. Many of these individuals had children after arriving. Under the current interpretation of the 14th Amendment, those children automatically receive U.S. citizenship simply because they were born on American soil. That one, seemingly simple rule creates ripple effects that touch almost every institution: public schools, healthcare, welfare programs, voter rolls, and long-term immigration pathways. But beyond the numbers, there is a deeper shift happening among the American public. People are beginning to ask foundational questions about sovereignty, borders, and what citizenship is supposed to mean. For decades, the United States has operated under a system in which being physically present in the country legally or illegally grants a child automatic citizenship at birth. That standard is unusual globally. Most countries require at least one parent to have legal residency or citizenship. So the real question before the Supreme Court is this: does the Constitution truly mandate unrestricted birthright citizenship? Or is there room for a more nuanced interpretation that reflects modern realities? The court's answer, whichever way it goes, will be one of the most consequential decisions of the century. If the court determines that the Constitution does not require universal birthright citizenship, it would dramatically alter the calculus for illegal migration. Right now, having a child on U.S. soil creates a legal foothold that opens future pathways to residency, benefits, and eventually sponsorship. Critics call it chain migration, and supporters call it a humanitarian safeguard. But the legal consequences are undeniable. Removing birthright citizenship for children of undocumented immigrants would eliminate one of the strongest incentives fueling border crossings. It wouldn't solve every immigration problem, but it would fundamentally change the stakes for those attempting to enter the country unlawfully. Of course, this raises emotional questions. These children are innocent. They didn't choose their circumstances. But law is not built solely on compassion, it's built on principles. The principle at stake here is whether a sovereign nation has the right to define its own citizenship rules. Nearly every country in the world asserts that right. The United States is no exception. But the Supreme Court's involvement signals something more than a legal debate. It marks a broader institutional recognition that the system is straining under the weight of decades of unresolved issues. For years, politicians from both parties have described the immigration system as broken. Millions wait in line legally, while millions more bypass the system entirely. That discrepancy erodes public trust and undermines respect for the rule of law. And while all of this is unfolding, an entirely different political earthquake is rumbling through Washington, one involving Marjorie Taylor Greene, Donald Trump, and the long-awaited Epstein files. During an interview on 60 Minutes, Greene unexpectedly revealed details of a private phone call with Trump. According to her, he was extremely angry that she had signed the discharge petition forcing a vote on the Epstein Files Transparency Act. For context, a discharge petition is a rare congressional tool that bypasses leadership and forces a bill to the floor. It almost never succeeds. But in this case, it worked, and the bill mandating release of all Epstein-related files passed with bipartisan support. Trump ultimately signed it into law. Greene claimed Trump told her that releasing the files would hurt people. Predictably, the media exploded. Headlines accused Trump of trying to hide something. Commentators insinuated that he feared exposure. But that interpretation oversimplifies the situation. Trump ultimately supported the bill. He could have fought it harder. He could have vetoed it. He didn't. That alone contradicts the idea of a cover-up. Instead, his initial frustration may reflect a very real concern. The Epstein files implicate many powerful figures across political, corporate, and entertainment spheres. Releasing everything without careful review could damage innocent people or jeopardize ongoing investigations. That's not paranoia. It's reality. Legal archives are filled with names mentioned in passing, in unproven allegations or in outdated testimony. A single out-of-context reference can destroy a reputation overnight. But things escalated further when 5 lawmakers, both Republicans and Democrats, sent a formal letter to Attorney General Pam Bondi, demanding an update on the release. They requested a classified or unclassified briefing before the statutory deadline, signaling that Congress is losing patience. At the same time, a federal judge in Florida approved the release of grand jury documents from an older Epstein case dating back nearly 20 years. Grand jury records are almost never unsealed.